So good morning and welcome to today's webinar on trade union recognition and industrial action. We're delighted that so many of you are able to join us today. My name is Fiona Herrell and I'm a partner in the employment and immigration team at Brodie's based in Aberdeen, although I have got Edinburgh Castle as my backdrop, I realise that. And I'm joined today by my colleague Gillian Donald, who I'm sure is known to many of you already. So today's webinar is the first of 3 sessions that will form our Spring 2023 Energy Academy. So back to today's session and what we're going to cover this morning. I'm going to start by doing a little bit of scene setting and why we picked to talk about this topic today. Gillian is then going to talk to you about trade union recognition and the various ways in which that can come about, whether that's on a voluntary basis as a result of a compulsory process or due to arrangements being inherited following a TUPE transfer of employees. I'm then going to talk about industrial action, including what that is, when it is protected, the processes that must be followed when it comes to things like balloting and giving notice of industrial action, and what an employer can do in response. And then we'll wrap up with some questions at the end. So in terms of setting the scene, over the last couple of years, there has been an increase in industrial action being taken, and there's a very good possibility that it has had a direct impact on you. That might be because you've had medical treatment which has been delayed as a result of strikes in the NHS, or perhaps your travel plans have been disrupted due to strikes on the trains, or by air traffic control, or by baggage handlers. If you have school-aged children, you might have had them at home a bit more due to teachers striking, or it may be that you've been expecting an important piece of mail to be delivered and that's been delayed as a result of Royal Mail workers striking. And the offshore energy sector has not been immune from any of that. And indeed, we've seen unprecedented levels of strike action being taken within the sector of late. So clearly it's had an impact on you, or it may have had an impact on you in a work context too. In terms of looking backwards just a little bit before we look forwards, the Offshore Contractors Partnership Agreement, which set minimum rates of pay and standards for employees, that had been negotiated by the Offshore Contractors Association and the union since about the mid-1990s. And by 2019, members of the Offshore Contractors Association felt that that agreement was outdated and that really it was no longer fit for purpose in the modern times. And they indicated that they intended to serve notice to terminate that agreement. The relevant unions, as you can imagine, were unhappy with that proposed course of action. They condemned the members' plans and they warned that industrial disputes were likely. Now, ultimately, a new deal was struck, and that has taken the form of the Energy Services Agreement, which is administered by OE UK, and which has the GMB, the RMT and Unite as the 3 signatory trade unions. And I'm sure you're all familiar with the ESA, but just for anybody on the call who's not, the ESA sets base terms and conditions of employment for thousands of employees working offshore in the UK. And significantly, it includes a rate adjustment mechanism, which is essentially a formula which is applied once a year for calculating changes to earnings, taking into account average inflation as well as the commodity price. And what the intention was at the point that the ESA and the RAM, as it's referred to, was agreed, was that the often lengthy and protracted pay negotiations that were taking place each year would be avoided and no longer required, because a simple calculation, it's not that simple, but a calculation would be undertaken and that would tell everybody what increase should be applied to the rates provided for in the ESA. But the ESA came into force in early 2021 at a time when I suspect most of us were not anticipating that inflation in the UK would hit 9 or 10 or 11% during the course of 2022 and would therefore have a drastic impact on cost of living in the UK. while at the same time operators in the sector would be announcing record profits due to, in part, the war in Ukraine driving up already high commodity prices. And so what we saw was individuals working in the sector being very critical of the wages that they were being paid as compared to the profits that were being announced. And initially, what we saw was some wildcat strikes in a bid to try and secure pay increases in face of these rising living costs. And that has now been followed by the unions getting involved. And as you'll be aware, a series of ballots being conducted, followed by industrial action being taken offshore. And for those of you who work in organisations that are not signatories to the ESA and do not otherwise recognise a union, what we're hearing is that the unions are seeking to capitalise on the momentum that they have garnered so far. And so they're approaching organisations like yours, and they're approaching your staff with a view to trying to get recognition agreements in place in companies that they're not already present. So with that all said, I'll pass over to Gillian, who'll get us started with some thoughts about trade union recognition.
Thanks very much, Fiona, and just let me add my own welcome to everybody joining us today. So if we first of all think about what trade union recognition is, if we take as our starting point the normal contractual relationship between an employer and an employee where no trade union is recognised, the employer and employee directly discuss all aspects of the employment relationship and any negotiation on terms. So for example, if the employee wants a pay rise, is directly negotiated with the employer, and agreement in this is usually implemented only for that one employee. Where the employer recognises a trade union for a group of employees, and we call the group of employees as it's recognised for the bargaining unit, the employer carries out negotiation with the union on some of the terms and conditions of employment, such as pay, holidays, and hours of work. That negotiation is carried out on behalf of that bargaining unit. So if an agreement is reached on pay, that would be implemented for everyone in the bargaining unit. And the negotiation process itself is called collective bargaining. Recognition of a trade union can be on a voluntary basis or on a statutory basis, where the union has undergone a statutory process for recognition involving the Central Arbitration Committee or the CAC. Whatever the form of recognition, where an employer does recognise a trade union for collective bargaining purposes, the union gains important rights, including its members and officials being able to take time off work. The union can require that it is provided with certain information about the employer to enable it to conduct collective bargaining. The union is to be consulted on proposed redundancies, and the union is to be provided with information and consultation on duty transfers, health and safety matters, and certain pension issues. If you do recognise one union as a bargaining unit, then the other unit, another union can't use the compulsory recognition to compel the employer to recognise it in respect of the same bargaining unit. And moving on to the next slide, let's take a more in-depth look at voluntary recognition. This is the most common way a union can gain recognition for collective bargaining purposes. Essentially, it's where the employer simply agrees to recognise a union voluntarily without the union going through a legal procedure. It's usually made by a union making an approach, which will often be in writing, to request the employer to agree to recognition voluntarily. Now, do keep in mind, please, if you do get a request for recognition in writing, be clear on whether it's a request for voluntary recognition or a formal request, which I'll speak about shortly, because if it is a formal request, there is then a deadline for you to respond to that. As set out in the second bullet on this slide, if an approach for voluntary recognition is made, the employer has a call to make on whether it engages with the trade union with a view to negotiating and agreeing the terms on which it's prepared to recognise the union, or to refuse the request, knowing the next likely step will be a formal letter from the union starting a statutory recognition process. Voluntary recognition can often therefore be seen as a more favourable option for employers, as it gives the employer greater control over what the trade union involvement can and will be. If you do decide to agree to recognition on a voluntary basis, ACAS, which is an independent public body providing advisory, conciliation and arbitration services to employers and employees. So ACAS can help the employer and the trade union to reach that agreement. Recognition agreements don't need to be recorded in writing, but I'm not going to surprise you by saying it is clearly better if a written recognition agreement is put in place. Also, keep in mind that trade union recognition can arise by implication, where an employer and a trade union conduct themselves so that a court or tribunal might infer that the union must be recognised for collective bargaining purposes. A voluntary recognition agreement is not a legally binding agreement with the employer and the union, but it does have contractual effect between the employer and the employee. And keep in mind that the effect of having a recognition agreement means that decisions made under that agreement will have effect on the individual's contracts of employment of everyone in the bargaining unit, regardless of whether they're members of the union or not, or even if they're members of another union that's not recognised. A potential advantage of voluntary agreements is that usually an employer is able to bring a voluntary recognition agreement to an end by simply giving notice. But of course, if the employer does that, it's unlikely to be the end of that story. And the likely next stage will be an application for compulsory recognition. And over the next few slides, that's what we're going to have a look at. So on the slide we've now got up, we've set out an overview of the statutory procedure for recognition. Some of this can be quite technical, so I'm going to try and just highlight some of the key takeaways for you from this process. The first stage is that the statutory procedure is commenced with the union making a written request for recognition directly to the employer. And as I said just a little earlier, if you get this written request in, be clear if it is a request for voluntary recognition or a formal request. A formal request needs to contain various details to be valid, such as the name of the union and which employees are part of the bargaining unit. And on receipt of this request, the employer really has 3 options on what to do, and importantly, 10 working days from the date on which the request is received to decide what to do. So you can either accept that request, and if you do that, then no further action is really required. That type of recognition is called semi-voluntary recognition. Secondly, you could reject the request and tell the union you're not willing to negotiate, or indeed, you could just not respond at all and let the 10-day period expire. Or third option is to reject the request, but tell the union that you are willing to negotiate. And that's what we set out as stage 2 of the process here. Negotiation between the union and employer in this scenario, there's further 20 working days for that negotiation period. And negotiation can be, for example, to agree who might be within that bargaining unit. If the employer refuses the request or the negotiations are not successful, then we move to stage 3 in the slide. And the union might apply to the Central Arbitration Committee, the CAC. Of course, the CAC might reject the application, and if so, the trade union cannot reapply for a further 3 years. Where the application is accepted, the CAC will then need to, as set out at stage 4, determine whether the proposed bargaining unit is appropriate, and stage 5, determine whether the majority of workers in the appropriate bargaining unit support the union. In certain circumstances, there might be stage 6, a ballot, and the CAC might issue a declaration that a ballot is not required, and that would simply mean the union is entitled to be recognised to conduct collective bargaining. However, an employer not wanting recognition is likely to want to build a case to the CAC panel that the ballot is necessary. And if that's accepted, the CAC will appoint a qualified independent person to conduct the ballot. The employer is under a duty at this point to cooperate generally with the ballot and give the trade union such access to workers in the bargaining unit as is reasonable to enable the union to inform the workers of the object of the ballot and to seek their support. Parties might want to drop an access agreement for that purpose. Then at stage 7, the qualified independent person is required as soon as reasonably practicable after the ballot has been held to inform the union and the employer of the result of it, and a declaration issued on whether the union is entitled to be recognised. If the union is to be recognised, then that's where we move to stage 8, and there is a further detailed process for establishing the bargaining procedure. It's quite technical and we're not going to cover that in today's webinar. Moving on to slide 8. First of all, there's various conditions that must be met for the trade union to obtain compulsory recognition. So we've set these out on the slide. The trade union must be independent. The employer must have at least 21 workers. The application must be made in the form prescribed by the CAC and the correct documentation given to them. The union must have provided the employer with the notice of the application, a copy of it, and supporting documentation. There must not already be in force a collective agreement recognising a union to carry out collective bargaining on behalf of that group of workers. The CAC must be satisfied that at least 10% of the workers in the relevant bargaining unit are members, and the majority would likely favour recognition. There are no competing applications for recognition from other unions, and the application for recognition has been made to the CAC no application for recognition has been made to the CAC within the previous 3 years in respect of the same bargaining unit. So if the group of employees who were the original bargaining unit has changed to perhaps include an additional group of workers, an application for compulsory recognition can be made in respect to that bargaining unit and within that 3-year period. And moving to the next slide, just a few more key points to highlight to you in this. You can see from this process that a hearing is not always necessary, and some decisions may be taken by the CAC panel based on the papers they have from the parties, or if it appears to the panel that there is no material dispute. So if you're trying to oppose formal application, it's important to ensure the CAC panel has sufficient details of the grounds for this. Don't just assume that you will get a hearing at which you can put that forward to them. The CAC is based in London, but it can have hearings at other locations that are helpful or convenient to the parties, and hearings would usually be completed in a day. If collective bargaining is imposed, it only covers pay, hours, and holidays. If the CAC has been involved, the recognition agreement cannot be terminated by the employer for at least 3 years. And as I've already said, this is also the case with semi-voluntary recognition. There is no appeal process in respect of a CAC decision. So that's a quick overview of recognition of the union. Moving to the next slide, we're looking at derecognition. And first of all, if there's voluntary recognition, that can be terminated at any time in accordance with the terms and conditions of the arrangement. Voluntary recognition is not legally enforceable. However, should you terminate the arrangement, the union may well be prompted to commence the process for statutory recognition. It's worth keeping in mind that terminating a voluntary recognition agreement does not have the effect of removing the employment rights incorporated into the employee's contracts through collective bargaining when the union was recognised. Where recognition is statutory, the employer can only apply for derecognition after the arrangements have been in place for 3 years. After 3 years, the employer can give notice to end the bargaining arrangement if it believes that it and any associated employer employs less than 21 workers. The employer can ask the CEC to arrange a derecognition ballot if it believes at least 10% of the workers in the bargaining unit are in favour of ending the bargaining arrangements, and a majority of them would likely be in favour of ending them. And a worker can also make that request. The employer can also ask the CEC to arrange a derecognition ballot if recognition of the union had already been declared without a ballot and the employer believes that union membership had subsequently been reduced to less than half the workers in the bargaining unit. A trade union can terminate a recognition agreement at any time. And as I already said, the webinar isn't going to cover the technicalities of collective bargaining and agreeing that process. However, I do want to flag that in the context of derecognition, if you are going through that process, do keep timings in mind and be clear that the union is derecognised before you commence any direct negotiations with employees that would have been covered by the collective bargaining agreement. Trade union legislation prevents employers from trying to buy employees out of the collectively bargained employment rights, and there's a risk of tribunal claims should there be an overlap between the two. So on this slide, we've set out some thoughts for you on recognition requests. And first of all, even if you haven't received a request for trade union recognition, the key here is communication. And it's really advisable for employers to just establish strong communication channels with their workforce. You might want to think about introducing employee representative forums and actively engage with the representatives. Might, on review, have a look at what workplace culture is like, and if necessary, work to improve it. Ultimately, if employees are happy with the direct communication channels that they have with you, they might be reluctant to have a union take over those negotiations on their behalf. However, employees may see a benefit in having a union recognised for collective bargaining, and they might think that it is easier for a group voice to be heard by an employer when discussing key terms such as pay. So if a request for voluntary recognition does land in your desk, the key things to think about in responding to it are who is in the bargaining group that the recognition would cover. Do you think within that group the union would have enough support to achieve statutory recognition? And would you be willing to agree the terms the union has put forward as part of its request? Or would you be willing to engage in a negotiation process with the union to see if agreement can be reached? Keeping in mind here, as we've already said, if you don't, the next likely step is going to be a request for statutory recognition. If the request for statutory recognition does land on your desk, first of all, keep in mind there are timeframes for responding to it. Consider if it is a valid request under the legislation, and I set out in our earlier slide some of the factors to consider when thinking about this. It's worth looking at the detail of the request and whether it's accurate, and if there are any errors, you might be able to rely on those in support of refusing the request should you wish to do so. Again, look at the bargaining unit that the request seeks to cover. Has the union previously sought statutory recognition in respect to the same bargaining unit, as there's a 3-year moratorium on statutory recognition following earlier failed applications for the same or similar bargaining units? And do you think the union would have enough support to achieve statutory recognition from the bargaining unit? Keeping in mind, of course, that once collective bargaining is in place, it can be difficult, although not impossible, to get out of it. And then moving on to the next slide, there's a third way that trade union recognition can occur, and that can be in the application of the Transfer of Undertaking Protection of Employment Regulations, TUPE. So trade union recognition will transfer to the buyer on the application of TUPE, where the transferred grouping of resources or employees maintains an identity distinct from the remainder of the transferee's undertaking after the transfer. Where this happens, the recognition agreement, whether voluntary or statutory, will transfer on its terms. However, it will depend on whether the bargaining unit remains a distinct identity after transfer, as if the undertaking is reorganised and fully integrated into the transferee's business, union recognition might not transfer. This can actually be quite complicated, and it might not be easy to ascertain whether the transferring employees have been fully integrated after the transfer or whether they retain a distinct identity. And if this arises, it's probably easiest to say it's best to take some specific advice on your situation. If the recognition agreement does transfer, the terms of it are carried over. So derecognition would remain an option on the terms discussed. But of course, you would potentially leave you facing industrial action or request for compulsory recognition. So I hope that that has been a helpful overview of recognition of trade unions. And I'm now going to pass back to Fiona, who's going to talk to you about industrial action.
Brilliant, thanks, Gillian. I mean, I guess before we actually get into industrial action and what is it, it's worth bearing in mind that in many situations, collective disputes that arise between an employer and its workforce or a trade union are normally capable of being resolved either through existing consultative procedures or existing sort of dispute resolution procedures. And so whilst it might not feel like it right now, historically, strikes and other industrial action are normally seen as sort of the measure of last resort. As I say, it might not feel like that right now, given everything that's going on in the North Sea and the number of ballots and strikes that are taking place, but trying to sort of set the scene and keep this all in context. In terms of what industrial action is, quite often people, when they think of industrial action, they automatically think of strike. A strike being an outright stoppage of work by employees acting in concert. And of course, that is a form of industrial action, and it's the most sort of extreme and severe form of industrial action that can be taken, given the disruption that it causes for the employer in our sector, not just for the employer, but for the operator of the relevant platform, particularly when we're thinking about safety cases, numbers of people on board who are performing safety critical roles and so on. So it definitely has the potential to be extremely disruptive and extremely costly. There are, of course, other types of industrial action that can be taken. So an overtime ban, refusing to work overtime, picketing, you quite often will see as you drive past a workplace of somewhere where there is strike action or industrial action ongoing, quite often see people, individuals gathering outside of the workplace, either to try and obtain or communicate information or to try and persuade others to abstain from work. And so when we're categorising industrial action, we're really talking about strike on the one hand, or action short of strike on the other. And it's important that we think very clearly from the beginning about what form of action it is that a union is potentially balloting our workforce about, because what we might be able to do if there were to be a disconnect is to point out that the ballot was for a particular form of industrial action and that it is a different form of industrial action that is actually now proposed to be taken or being taken, and therefore there's a disconnect between the two, and we might be able to sort of make much of that. If we move on to the next slide and thinking about industrial action, and thinking about some of the questions that our clients ask us, particularly in businesses that are not experienced at being unionised or have relatively short history of dealing with unions, and also in particular some of our experience of dealing with clients who have foreign owners who are being asked questions coming from management in countries that don't really have the same industrial relations and collective bargaining landscape that we have here in the UK, we quite often get, is that lawful? Can they do, can they do that? Is that lawful? The reality, of course, is that a strike and almost every other type of industrial action will be unlawful, given it involves the employees breaching their contracts of employment. So in the case of strike action, the individual has entered into a contractual agreement with their employer that they will provide their labour in return for pay, and during the period of strike action, they are unilaterally withdrawing their labour without the employer's agreement. So a clear breach of the employment contract. And from the union's perspective, the union that arranges the strike or other industrial action will usually induce that breach of the employment contract, and that's often referred to as being an industrial tort, and there may be other industrial torts committed too. And so the starting position is really that the union is exposed to legal claims from the employer, either for interdict or injunction, depending on the jurisdiction, whether it's a Scottish or an English matter, but the output is the same. It's an order from court to say you cannot organise the strike, you cannot have the strike action ongoing, or if you don't manage to get to court in time, or your application for interdict or injunction is unsuccessful, a claim for damages, so for the costs that you as the employer have suffered as a result of the industrial action. However, there is a sort of get out of jail card for unions, in that the legislation provides for the potential for there to be statutory immunity for the unions from claims by employers. The legislation is the snappily named Trade Union Labour Relations Consolidation Act of 1992, which is a very long piece of legislation. It's actually very complex, and it's Part 5 in particular that is relevant here. And if a union is able to show that the industrial action is lawful, in that the requirements of that Part 5 of the legislation have all been satisfied, then they will be able to have immunity, and the employer's possibility of seeking interdict or injunction or damages will fall away. And that is why what you often see is where there are discussions or planned or actual wildcat strikes or other industrial action, that the unions will be very quick to denounce them and to create some distance between the union and that action, because it doesn't want to have any situation which the employer might say that the union has authorised or endorsed that industrial action. And in my opening, I sort of referred to wildcat strike action back in September 2022. And we saw that very quickly, Unite in particular coming out, this is not the way forward, this is not the way we do things, this has the potential to jeopardise everything, we do not support this action. And that was the reason why they did not want in any way to be exposed to potential legal claims from the employers who were facing that action, that they had induced the breaches of contract and therefore were on the hook for potential damages. So we come on to the question of, well, is the action protected? When will the union have immunity from legal proceedings? And as I set out on the slide, there are a number of requirements, all of which have to be met in order for the union to have immunity. So we start with the industrial action must be taken in contemplation or furtherance of a trade dispute. And we'll have a look shortly about what that is actually, what's actually meant by a trade dispute. That the action has the support of a properly organised ballot of union members. Again, we'll have a look at balloting. That the union has complied with the various notification requirements that are set out in the legislation. That the action is not being taken for a prohibited purpose, and the legislation tells us what those prohibited purposes are. And that the action does not amount to secondary action or unlawful picketing. And if the union can tick all of those boxes, then it gets a sort of get out of jail free card and has the statutory immunity under the legislation. Worth flagging, though, that there may be other types of claims that arise in the context of industrial action which are not covered by the statutory immunity. So, for example, you might have a situation where it's considered that there has been harassment or nuisance or trespass, and that might particularly be the case if you're facing picketing. There is no immunity for the union arising in respect of those sorts of claims. And similarly, if you were to be in a situation where criminal offences are committed by individuals in the course of industrial action, such as assault, if things really escalate at a picketing line, for example, then again, that sort of offence would be dealt with by the criminal law in the normal way, and the statutory immunity under the legislation would not apply at all. So I said we would have a look at what is a trade dispute. It is one between workers and their employer, relating wholly or mainly to, and then that big long list of various different employment related matters. So basics like terms and conditions of employment, of course, but even things like allocation of work or duties between workers or groups of workers, disciplinary matters, facilities for union officials. I think when you look at the list in its entirety, what you can see is that trade dispute is not really intended to be a narrow concept. It is intended to be quite broad. But nonetheless, if you were in a situation where there was some sort of collective dispute within your organisation, you'd want to have a think about whether or not it is a trade dispute in the first instance before you go much further. And we just popped on the slide that there can be a trade dispute which relates to something outside of the UK, provided employees in the UK are affected by the outcome. So worth bearing that in mind too. You'll remember that in order to get the immunity, I talked about sort of balloting and notice requirements. So we've just set out on the slide here the requirements in terms of a notice of ballot and the timeframes that must be complied with. So the union must send the employer the notice of ballot no later than 7 days before the ballot, and a copy of the ballot voting papers no later than 3 days before the ballot. And the notice of ballot must be in writing. And again, there's particular information that must be included in the notice of ballot. So things like the total number of employees concerned, and that's being those that the union reasonably believes will be entitled to vote in the ballot, the categories to which the employees belong and the numbers in each category, list of the workplaces at which the affected employees work, the number of employees concerned at each workplace, and an explanation as to how the given numbers were arrived at. And the information must be as accurate as reasonably practicable in light of the information the union holds. And quite often we get questions around, well, we don't know if their numbers are quite right. Is it worth us sort of trying to explore that? But I think there's some acceptance that the union's data and numbers might not always be bang up to date, and because it's only as reasonably practical in light of the information the union holds, you're probably unlikely to get very far if you try and sort of challenge a notice of ballot on the basis that you don't think the numbers are quite right. If they're blatantly wrong, different issue. In terms of the balloting process itself, if there are more than 50 members who are entitled to vote, the union must appoint an independent scrutineer to run the ballot. They should specify how to run the ballot, and in some cases they will actually go on and conduct the ballot, and the union really has to take a back seat at that point. There are particular balloting rules which must be complied with, but again, minor accidental breaches will probably not invalidate the vote. Nonetheless, employers should, to the extent that they can, try and monitor the conduct of the ballot. So, for example, are they hearing that members are complaining that they've not received ballot papers, or is there any evidence that some individuals have received ballot papers when they shouldn't have, for example? Issues like that, if you're hearing it, might suggest that there are more fundamental issues with the ballot that's been undertaken, and might sort of give you cause to query the approach taken with the union. And in terms of announcing the result, the union must take such steps as are reasonably necessary to do that as soon as reasonably practicable to everyone who is entitled to vote and their employers. In terms of the levels of support that are required, a strike or other industrial action will only be lawful if at least 50% of all members entitled to vote in the ballot did so, and at least 50% of union members who responded to the ballot voted in favour of action. So if you had 100 members being balloted, then at least 50 must vote. And if 50 vote, then at least 26 must vote yes for there to be a valid mandate. Whereas if all 100 vote, then you would need 51 to need to vote in favour. So again, when you're thinking about sort of industrial action and receiving a notice of ballot, worth thinking about, do you think that the union will be able to garner that level of support within the members, or do you think that it might end up being that they're not able to get there? In terms of assuming that the ballot is in favour and those thresholds are successfully met, the union must serve a notice of industrial action on the employer at least 14 days before the start of the action, unless the employer agrees to a 7-day notice period. Again, there's legislation requirements around what a valid notice of industrial action must include. Clearly, it's got to be in writing. The union's got to tell you whether the action will be continuous action or discontinuous and give you the dates. The notice of industrial action must have been served on all of the employers of each union member the union has reasonable grounds to believe will be induced to take part, and again providing certain minimum information, with that information requiring to be as accurate as reasonably practicable in light of the information in the union's possession. So again, that sort of same wording that we saw a few slides ago. What can we do if the union doesn't comply? Well, as I said, if the union doesn't comply, there's potential that it doesn't have immunity from claims that the employer might be able to bring against it. So it is really important that we carefully scrutinise what has been done. Is there a trade dispute? Have they complied with their notice of ballot requirements? Has the ballot itself been compliant? Have they complied with their notice of industrial action requirements? Because errors might mean that the union will lose its immunity. And actually, even writing to the union to say, we think that you have made a mistake, we've identified these flaws in the process, we think that we could go for an interdict or an injunction, but why don't we reconvene and see if we can't resolve this once and for all, might actually be quite a powerful way to proceed without incurring the costs of actually applying for interdict or injunction, and also without having the inconvenience of the industrial action being carried out. There are, as I said earlier, some balloting process errors which will be disregarded if accidental. So if they're sort of relatively minor, unlikely to affect the result of the ballot, and accidental, then these are not going to cause issues for the union and its potential immunity under the legislation. The notification requirements, though, it's different. Those are strict requirements and there's no specific get out for accidental failures. And in fact, there is an example where an interdict was granted in circumstances where a union incorrectly served notices on the parent company instead of the employing subsidiary companies. And that is an easy mistake that can be made because quite often the employment structures within some of your businesses can be quite complex, and we see that too. So you can easily see how a union might accidentally refer to the wrong employing entity, particularly if you have people employed in various different subsidiaries, depending on which operators they're working for or which platforms they're working for, or however you structure it. So definitely worth paying attention to that and having a look out for that. In in terms of responding to industrial action, then what should you be thinking about? As I said at the sort of beginning of this section of the session, it is normally the case that it will be possible to resolve collective disputes between an employer and its workforce or its trade unions through engagement and ongoing communication. So just because you've got to the point where so far that has not proved fruitful, it is normally the case that we would recommend that you try and keep that line of communication open, that you try and keep that dialogue ongoing, that the parties continue to come back to the table and discuss further with a view to trying to resolve the matter, because ultimately it is normally the case that clearly the employer doesn't want industrial action, but perhaps neither does the union and neither do the members. It's just that we've got to this sort of really difficult stalemate position and we need to do something to try and break through that. So continuing to engage and discuss with the union is normally a good idea, as is continuing to communicate with staff about why the position has got to where it's got to, being very careful, I think, as to the language you use and how you describe the situation, and not saying anything that could possibly be inflammatory or disparaging or derogatory of the union, clearly, but trying to make sure that your workforce are hearing your narrative and your story as to why matters have got to where they've got to, and how you see things moving forward. Also recognising that many of the people who might be contemplating taking industrial action may never have done so before. And so it's something that they've heard about or read about, but it's not something that they've ever actually been asked to consider whether or not they would do it. So explaining to them what the industrial action form will be, and what that means for them in terms of breaching their contract of employment, what impact it might have on them for pay, and so on. I think, again, so long as it's not done in sort of an intimidatory or way that could sort of amount to harassment, but just a sort of information sharing, educational piece can also be quite important. Nonetheless, that's sort of your starting point. You need to have your backup plan, right? Because this might not get resolved. And so thinking about how will you get the work done if for example, say the industrial action that's proposed is strike action, so you're going to have a withdrawal of labour. How are you going to get the work done? What does that look like? Until 2022, there was a prohibition on being able to use agency workers to cover the work that would normally have been undertaken by the individuals participating in the strike. That has been lifted as a result of legislation. Worth noting, though, that a number of the unions have challenged that legislation, and the High Court has granted a judicial review of it. So the position on that might change, but as things stand at the moment, you can use agency workers to try and cover the work. Now, there might be issues about finding agency workers who have the particular skills, expertise, offshore certificates, and so on to be able to do that work. But worth remembering that as things stand at the moment, you can look at agency workers. You might also want to have a think about if your individuals are working some sort of rotation pattern, then whether it would be whether you'd be able to sort of speak to individuals who are not rotated to work whilst the strike action is to take place, to see whether any of them would be willing to cover it. They might not be, and they wouldn't be under an obligation to do it, but you would have those sort of back-to-backs subject to sort of health and safety considerations around their working hours and working patterns. You might also want to have a think about planned holidays and whether you have the ability to give notice to require people to cancel their planned holidays in order that they're able to work. Again, what you might find is that those individuals have their holidays cancelled and then they just participate in the strike. But there are a number of different routes that you can take to try and make sure that you're going to be able to cover the work. And so it's good to start thinking about that from an early stage and doing some sort of workforce planning on that. To the extent that there are individuals who do withdraw their labour and do not attend for work when they are meant to, then you are permitted to deduct from their wages for their failure to work. So having a think about what that deduction looks like in terms of the amount, having payroll lined up and ready to implement those deductions will also be important. You might have a situation where people are refusing to perform all of their role, but are saying that they will do some of it. And there's a question mark there as to whether or not you're willing to accept partial performance. And I think that will be sort of very fact specific. So probably don't propose to say much more than that, but just have a think about it if that does arise in your particular circumstances. I've popped on the slide, consider dismissal an action shorter dismissal. I feel like I should have covered this with sort of red flags and health warnings all over. Because actually when I looked at it again, I thought that sort of suggests like that is an option. It might be in some cases an option to think about that, but it is certainly not a sort of go-to first course of action. There are various protections that will apply to individuals who are participating in sort of official industrial action that is protected, and dismissing them most likely will result in automatically unfair dismissals. So I think if you were in a situation where you were looking at that, I would definitely be stressing or encouraging you to take specialist legal advice as to what the options are and what the risks are if you proceed. And of course, right now, with the way that the labour market is and the shortage of skilled staff that many of our businesses need to operate, I'm not sure that that is really a particularly attractive option anyway, even if it weren't for the risks, because actually in many of our businesses, we really need these people to do the work. And there's a shortage of them in the market generally, so we can't just pop out and replace them very quickly. And then your final point clearly is the final point on my slide, but perhaps it's one that you think about much earlier, is considering applications for interdict or injunction and damages claims. Now, the reason I'm saying maybe you should be considering that much earlier is because you, if you're going to go to court and seek an interdict or an injunction, you need to do that really quickly because you've got a short period of time within which the industrial action might be about to start. And so you need to try and get into court before that happens with a view to getting an order to say that it cannot happen. So again, that should probably, these aren't really in order, but it should maybe, if they were in order, it should maybe be sort of higher up the list. And again, I think that's one that you should be taking specialist legal advice on as to whether you would be likely to get an interdict or an injunction in the first place. Just a couple of points to flag on reform in this area. So I've talked already about the agency worker position having changed from July last year. The judicial review application was due to be heard in March of this year, but we've not heard further on that. So it's a watch this space for just now on the position in relation to use of agency workers. The damages that can be awarded, the maximum amount has increased again from July last year. So the range is now £40,000 if the union membership is less than 5,000, to £1 million if the union membership is 100,000 or more. So that is quite significant in terms of the amount of damages that could be ordered to be paid. You might have seen that there's been lots of talk about minimum service levels during strike action, and this is the government taking steps to introduce minimum service levels in certain sectors during periods of strike action to ensure the safety of the public and their access to public services. There's no suggestion at the moment that that would extend to sort of offshore oil and gas, but just flagging that for completeness. And there have been over the years some other reforms that have been proposed, including in relation to raising ballot thresholds, increasing the minimum notice of industrial action, and reducing the period in which unions can call industrial action after a successful ballot. But as things stand, it's not yet clear if any of these proposals will be implemented, and if they will be, when they will be. So it's probably just for a sort of longer term view that these might at some point come into force. In terms of some useful resources for you, if you are dealing with this in your organisation, included the legislation itself, there's then a code of practice on access and unfair practices during recognition and derecognition ballots. There's some industrial action and law guidance. There's codes of practice on industrial action ballots and notice to employers and picketing. There's obviously the Energy Services Agreement itself, which I'm sure you'll already be familiar with, but there's an Energy Services Agreement code of practice on trade union representation and workforce engagement. So what we'll do is when we send out the recording of today's session, we'll include links to these various documents so that you've got them all in one place if you do ever need to look at them. And it goes without saying, of course, that Workbox by Brodie's, our online HR and employment law portal, has got some fantastic resources in relation to industrial relation matters, including bargaining, collective bargaining, recognition and industrial action. So if you are a Workbox user, then I would definitely recommend that you check out that section of the site if you're dealing with this within your business. If you're not a Workbox user and you would like to have a demo and trial access for a few days, then drop Gillian or I a note after the session and we can get that arranged. In terms of questions, we've got a couple of minutes left. Do you want to, have you had a chance to have a look, Gillian?
I have. So there's one that I'll ping to you initially, I think. So there's a question about how you would deal with employees who report in sick during strike action.
Yeah, good question. So you might have individuals who are long-term sick who are covered by sort of existing medical notes, in which case they just are treated as being sick in the normal way. You might, though, in relation to individuals who in advance of strike action who are currently attending work but might participate in strike action, make it clear that individuals who report as sick during the industrial action will be required to provide a medical certificate confirming their sickness during the period of absence, because of course from a pay perspective, if you pay full pay during any period which when individuals are self-certifying, then it sort of, from an employee's perspective, it means that they're contributing to the disruption because they're not providing their labour on the days that the industrial action is taking place, but they're not going to be deducted from pay, have their pay deducted because they have certified as being sick. So you just want to have some mechanism in place to try and make sure that the individuals are actually sick on the days that they say they are sick. And then Gillian, if you do recognise a trade union, you talked a little bit about the rights that the union have and the fact that they can ask for sort of certain information in order to sort of perform their collective bargaining. What information do you actually have to give them about your business? How much do you have to give? So
there's a legal duty on the employer who recognises the union to disclose matters requested by it, and it's quite a wide duty. Essentially, the information needs to be in relation to the employer's undertaking, information that if the union didn't have, they would be impeded to material extent from carrying on collective bargaining, and that it would be in accordance with good industrial relations to be disclosed for the purposes of collective bargaining. There's also an ACAS code of practice on this, and that contains a non-exhaustive list of examples of information to be provided, and that might be on pay and benefits, conditions of services, etc., etc. The code does confirm, however, that an employer does not need to disclose information that might cause a substantial injury to the employer, such as cost information on individual products, marketing, pricing policies, etc.
Okay, great. I'm conscious of the time, so I think we should probably wrap up there, but thank you all very much for attending the session. Otherwise, yeah, thank you very much for attending and have a good afternoon.